All right, now welcome to the TuckerAllen virtual broadcast as we talk today. As I mentioned earlier on Facebook Live, I'm Scott Trout, and I always am your host for Facebook and TuckerAllen Live on Facebook. But today we'll be joined by Kevin Mason and Teresa Yao, who will be taking care of matters today. I just wanted to introduce everyone to the webinar for today with some important topics to talk about. As I mentioned earlier on Facebook Live, we have the holiday celebration here, and we want to make things joyous, but it's always filled with stress. And one of the stressors are the unknown. The CDC talks a lot about the pandemic. We know that's a stressor, but it also talks a lot about the increased risk during the holiday season for illness, for slip and fall, for heart attack and stroke, the things that just create more stress as we go through the holiday season. And we always talk thoroughly about taking some of the bad times and making them some of the best of times. And there are certainly things that you can do. And that's one of the reasons you're joining us today. And that is through proper planning. And that is making sure that you can kind of take those stressors out and putting yourself at ease and to meet with an estate planning attorney. And that's what the points that they're going to go through today. We talk about those things that really is bypassing panic, replacing panic with proper planning. Some of the easiest things that you can do is picking up the phone or grabbing your computer, logging on, for example, to TuckerAllen.com. You can go through and schedule an appointment and ensure through proper planning that you can take care of the matters that are most important to you. No better time than doing it now. Avoid the statistical increased risks through that proper planning. Most of the individuals who log on and contact us have no planning. For many months now, we've been talking about durable powers of attorney. We've been talking about, if you've watched the GO package, if you don't know what the GO package is, you need to find out what that is. A critical component of estate planning, making sure that the things that are most important, those financial documents, those records, those powers of attorney are in a correct place. There's certain things that you can do right now by taking action and taking the easiest step, and that is scheduling a consultation. We've talked about it a lot with an attorney who practices exclusively in estate planning, like the attorneys at TuckerAllen do. So we want you to do that, to bypass that panic. And that's what today is all about, is to get some paper, get a pen, let's take some notes. But as I always caution before we turn it over to Teresa and to Kevin will be moderating for us. And that is, make sure this isn't legal advice. We don't want you to take that. There is no substitute for having a consultation with an attorney. You can do it via Zoom, just like this, from the comfort of your home, from your office, wherever you are, or you can do it by phone. You can schedule that online with the attorneys. We've got offices in the Kansas City metropolitan area as well as the St. Louis metropolitan area, including across in Illinois. So we'd encourage you to take care of business and log on and find more information about TuckerAllen. So today's seminar, we're going to get right to it. It really is about eliminating risk and reducing stress. And you got to do that now, though. We're getting into the months that the CDC says between November and January. Take COVID out of the mix. If we weren't dealing with COVID, we'd still have the same increased risk, which is, heart attacks and strokes and slip and falls for any age. It just goes up substantially during that period. So without the planning, that creates the issue. So that's what we want to do and provide this seminar to you today for proper planning. So I'm going to turn it over to you, Teresa, and you can take it away. And Kevin, give everyone the information they need to bypass that panic and put in place proper planning. So check out, continue to watch out for Facebook Live as we go with TuckerAllen Live on Facebook and our virtual town hall coming up in December. So to you, Teresa, take it away.
Thanks, Scott. Thanks for having me. Welcome, everybody. Give me a quick second here. I'm going to pull up the slides and you can see what I'm looking at and we'll get started. All right. So just like Scott was saying, right now, of all times, even during this pandemic, I think there's quite a bit of panic and kind of fear going on with regards to COVID-19, especially going into the holiday season. And that's why we really thought today's webinar is a timely topic to discuss so that you have an estate plan in place, or you can revisit an estate plan that you've created in the past and come talk with us. We're happy to meet with you, whether that's in person or virtual or by phone. We're happy to meet with you to discuss what can put you at ease in this time. All right. So today's webinar topic is bypass panic with good estate planning. So generally, I'm just going to go over the agenda for today. Number one, I'm just going to review the handout materials that you should have received in the same email where you got the Zoom link. And I'll just go over a little bit about myself so you get to know who I am and as an estate planning attorney and also as a person for why I'm doing this kind of work. And I'm going to then turn it to you and based on what we've heard from our past clients, identify what we've heard that you're interested in knowing about an estate plan. Then we're going to talk about how do we even go about creating an estate plan that can really afford you that peace of mind. And lastly, after we come up with a plan, let's get an action plan in place so that you actually have these concrete steps that you can take to get this started. All right, so with the handout materials, I think it's pretty simple. It's just a note sheet that should have been included with that Zoom email, and I'm going to be covering a lot of material today. So just make sure you take notes of the highlights that I mentioned, as well as any questions for you to keep track of. I know Kevin's fielding those questions, and he'll let me know which questions that I can kind of reach out to and answer for you. All right, a little bit about me. There you can see my lovely family. So as an attorney, I'm licensed to practice in Missouri and Illinois. And why I got into this work is I'm fortunate enough to have a really tight-knit family. And I think part of that really makes me look for human connection in my job and kind of taking care of other people's families as well, which is why I got into estate planning. All right, so enough about me. Let's talk about you and what we've gathered based on our surveys with past clients about what you want to know. So here we have a list of the most common questions that we get. So number one is, can I protect my assets from the government or long-term care? That's a big one. Or even in some situations, if there's family members that you want to make sure assets are protected from, or if you want to make sure that you're protecting assets for a certain family member that they might not be able to manage their assets the best themselves, so that you want to make sure whatever you give to them is used wisely, stuff like that. And another common question is, what is a trust? So I'm sure most of you have heard of wills, and a lot of you have probably heard of trusts, but I think the distinction between the two can be kind of confusing to a lot of people, and I'm here to dispel that or to clarify those differences. And even within the trust world, another common question is, well, I've heard of revocable trusts, but I've also heard of this thing called the irrevocable trust. Should I have both, or should I just have an irrevocable, just have a revocable? I'll cover both of those estate planning instruments so that you know kind of what is the best estate planning instrument for you. And then after that, I'll also cover how can I avoid probate. Most of you have probably heard of probate or dealt with probate. The common consensus is it's not a very good thing. We try to avoid it. And so some people say, well, do I really need to, if I've set my assets up a certain way, do I need to do anything extra to avoid probate? I think the takeaway to that, I'll get more to those answers, but the main takeaway is avoiding probate is kind of like walking through a minefield. You really have to be careful about how you set things up so that your assets don't have to go through the whole court system. And then we also get questions like, can or should I give my quote unquote stuff to my kids or others? Should you give those for when you're alive, or should you just give everything away after you pass away? And then if you do want to give stuff away for asset protection purposes while you are still alive, does that mean it'll take 60 months for it to be safe? A lot of people have heard about this magic number of months to wait out before your assets can be safe. And I'll go into where that 60-month timeline comes from. And other questions we get is, what is a power of attorney? Scott referenced this in the introduction a bit. We've been talking about it a lot here. We think that really is the basic building blocks. If you don't have an estate plan, please at least have a power of attorney in place. So I'll go over what those are, and included with powers of attorney, a lot of times we also have living wills and a healthcare proxy. So I'll describe what those instruments are and also what the differences are between them and which of those do you really need right now. Other questions we get are, how can I plan for my disabled beneficiaries? And a lot of people have IRAs, and their IRAs are a large chunk of their estate. So people ask, how do I keep my IRA safe? And do I need to include any special planning for them? And lastly, we also get some questions about estate taxes. People want to ask about, well, if I leave all this stuff to my kids and to my wife or to my husband, how can I make sure that I avoid estate taxes and that they are getting as much of my assets as possible? All right, so before answering your questions, I kind of just want to present you with a couple of shocking facts. It's shocking to me when I first heard about them, but only 4 in 10 adults have a will or a living trust. That's less than the majority, and that is very surprising and scary to me, because having a will or a living trust, either one or both, is so fundamental in affording you that peace of mind, so that you can make sure that you got things set up and that the assets are going to be tied up or be exposed to a lot of conflict. And so I would really love to see that number increase over the years, where we can go to, 60%, 80%, 90%. But as of now, only 40% of people actually have a will or a living trust in place. And this goes to the audience members where you have created that estate plan. That's a great first step. But I think an important question to ask yourself is, does your current estate plan actually meet your goals? And we really encourage our clients to revisit their plans, because again, the second statistic I saw that is that only 10% of estate plans actually accomplish a person's current goals. And that's not a great number, right? You took the effort to create your estate plans. You took the effort to create your wills and your living trust. So you really want to make sure that these documents outline exactly what you want to happen and really meet your goals and your wishes. So just please make sure you're not in that 90%. If you have an estate plan, I think it's really worth it to revisit and to sort out whether your priorities are spelled out in it. All right, so essentially for me, the goals of today's presentation is to help you identify if your current plan actually meets your goals. If it does, great, I'd love to hear that. But if it doesn't, we'll kind of talk you through about what we think you need to include then. And the second goal of the presentation is I want you to understand what it takes to protect you and your stuff. So a lot of times people think, oh, I just have a revocable trust and I have my will, and that's enough to protect my assets. It affords some protection, but if you really care about asset protection and preserving assets for your kids or your beneficiaries, there are other instruments that can achieve that goal better. So I'll discuss that. And then the last goal, I think it's the overarching goal here, is just to show you what might be missing in your estate plan. And if you realize that you're missing something, come in and talk to us and we'll get that set up for you. All right, so I like to break things down into steps. And in terms of bypassing panic with an estate plan, there's really 3 steps that we take. So number 1, we want you to know the rules. And what I mean by the rules are, what are the laws that are in place that kind of relate to estate planning, and what does that mean in terms of you setting it up? So number 1, we want to know what rules, what parameters do we have to work around? And then number 2, after knowing the rules, also know about what the risks are. So yes, we have these documents that we can create for you, but in creating documents, depending on if you're creating it on your own or you're creating with an attorney, there's potential risk, and you really want to make sure that you mitigate those risks as you go around creating your plan. And then the final step in creating your estate plan is knowing your options. So now that you know the rules and the potential risks, what are your options in terms of actually creating a complete estate plan that respects the rules, avoids the risks, and accomplishes your wishes? All right, so number 1, know the rules. I'm gonna divide this into a couple of sections. So the first section is about government rules. So by law, what's in place to take care of you? What rules are in place to take care of you? And I like to divide this up into during your lifetime and after you pass away. So number 1, the government rules that apply while you are alive. So in an estate plan, when you are alive, we primarily think of the documents such as your powers of attorney. Your powers of attorney are operative while you're alive, and they are essentially where you can share your decision-making powers with agents that you appoint. So who has the authority under these powers of attorney? It's your agents, and also we highly encourage people to set up successor agents. So your first choice, your second choice, and your third choice. So that if somebody is unable to or unwilling to serve for whatever reason, you've got a backup, and it doesn't just default to what I'll cover with guardianship or conservatorship, where you definitely want somebody you know is capable and that you trust to be able to step in to make decisions for you. So by law, there are instruments for a financial power of attorney that can help you make financial decisions and also help you execute a few legal actions as well. There's limitations on that, so you definitely want to visit that document to be very clear about what powers your agent actually can exercise. And a sister to the financial power of attorney is the healthcare proxy. This is also known as the healthcare power of attorney. So same idea, except you're sharing your healthcare decision-making powers with somebody else. Here, instead of just who is most capable, I like to encourage my clients to think about who in your life do you think shares the most similar values to you, so that you know that they would make the same decision as you would about your health and your body if you were not able to speak for yourself. So think about that in terms of setting up your healthcare power of attorney. And almost always we couple a healthcare proxy or healthcare power of attorney with a living will. And a living will is a direct testament. So a healthcare proxy, you're appointing somebody to speak on your behalf. But a living will, you're speaking directly to your doctors, and it only pertains to end of life care. And a living will allows you to make that testament saying, hey, doctor, if you determine that I have a terminal illness and it's irreversible, I don't really have a chance of recovering or living a meaningful life after, then I want you to just focus on palliative care, comfort care, withhold life-sustaining treatment. So that's kind of a testament that you can couple with your healthcare power of attorney to make sure that your wishes are really fully covered even when you become incapacitated. So we love those instruments. And as I was just saying earlier, if you don't have an estate plan at all and you're not ready to go dive all in yet to a full, like a trust package with wills and deeds all set up, I would highly encourage powers of attorney are very helpful documents to get in place as soon as possible. And the reason I say that is if you don't have a power of attorney for finances or for healthcare while you're alive, if you're incapacitated, and your doctors or financial institutions don't find anybody that can speak on your behalf, essentially somebody has to start a guardianship or a conservatorship hearing or trial for you. So you have to be appointed by the court. A guardian or conservator has to be appointed by the court to be able to act and speak on your behalf. This can be a really arduous process. Anything with the court system, you're essentially waiting on their timeline. Even for emergency guardianships, you still have to, a lot of times it's really ticky-tacky, so you have to hire an attorney to get that done as well. You need to get a doctor to testify as to the incapacity of the person that requires the guardian or the conservator. And like I said, you'll need to go to a hearing, and a hearing is essentially like a trial, where if anyone contests the guardianship, there'll be arguments from both sides, and the judge will ultimately decide, hey, this is the person that I think should be the guardian or the conservator. So I would say, if possible, powers of attorney are so much easier to get done than getting a guardian or conservator appointed. So please put that on your to-do list by the end of 2020, I would say. All right, and now we are transitioning to the government rules for after death, so after you pass away. So what happens if you do have a will? Well, if you have a will, good for you, because you are able to set some of your wishes ahead of time so that the court, the government, can know what you want done. So you get to appoint who's in control, so who the executor is. In Missouri, we call it a personal representative. So you get to appoint somebody that you know is responsible and will take care of your assets and is savvy and will handle all of this expeditiously, responsibly. And you also get to say who gets your stuff. Instead of having the state dictate by their default laws who gets your stuff, you get to say, hey, I want these people to be my beneficiaries. Here's the percentage share I want to give to each of them. Here's how I want them to receive it, whether it's outright or maybe like you want to disperse it at different age points. You can do that. But I do want to dispel a common misunderstanding. With wills, you're not avoiding probate. Okay, so I like to think of wills as like an instruction sheet to the probate judge. You have the will set up, so you clawed back some of that control. So instead of leaving it all up to the state to handle, you tell the court, hey, this is how I want you to handle my things that are going through probate. But all the downsides of probate, the delay, and I'll get into that later, the delay and the state having to say, keep your estate case open for a certain period of time so that creditors can come forward. All of that still is included, even if you have a will. Okay. And then, so what if you don't have a will? What if you didn't take that time to set up this instruction sheet to the probate judge? Well, if that happens, then essentially you pass away what we call intestate. Intestate just means you don't have a will. But to the best knowledge of everyone, they don't know what your wishes are. So then the court has this certain process to carry out your assets through the probate. So they have an intestate succession. So in Missouri, instead of everything going to the spouse or things divided equally between the spouse and the kids, they do, hey, 20,000 off the top to the spouse, and then everything else divided equally to the spouse and kids. A lot of times that's not what people want when they want to distribute their assets. So that's why we really encourage you to do a will. So essentially, and you don't get to decide who the executor is. The state will appoint that personal representative. If a creditor finds out that you pass away, the creditor may even open up a probate estate and be your personal representative. And that would be a really unfortunate situation. So I've been talking about probate, and like I said, it's a court process, and oftentimes there is a delay because depending on how many assets you're bringing through probate, that can be a lengthy period of time to inventory everything that was in your estate, and then to evaluate the different assets that is in your estate. So that can take up a really long time. And it can be quite costly as well. Missouri requires you to hire an attorney to deal with probate. And Missouri also has statutory fees for going through probate. And the statutory fees can run from 5% to 20% of your total estate. So that's a pretty fair chunk of money that instead of paying the courts and paying an attorney, you could be passing down to your kids instead. And then one last thing that a lot of people don't think about is that probate is also a public matter. So anything with the courts, it becomes a public matter. So anyone during your probate hearing can walk in and listen to the different assets and how things are being distributed. So to our abilities, we normally like to not just have wills, because wills don't avoid probates, and we like to build in trusts as well. And I'll go into detail later about how a trust actually helps you avoid probate. All right, so now the second kind of category of rules I like to think about with Know Your Rules is in estate planning. I think it's a really important distinction to make between documents and planning. So when you look at your estate plan, you don't want to see them as, oh, these individual documents that work separately from one another. You want to make sure that all these documents work together and that the documents, the content of them themselves actually accomplishes your goals, right? When I say planning, I mean, hey, we're planning based on your priorities. We're not just giving you a boilerplate document that is legally valid, but not much else. So for example, with a power of attorney, you want to ask yourself, hey, is my financial power of attorney powerful enough? Have I actually given my financial agent enough powers to effectively act on my behalf? Sometimes I've seen powers of attorney where the powers are really limited. So even though you appointed somebody and it's a legal power of attorney, it doesn't really have much teeth to it. So it doesn't really accomplish your goals. And you also want to ask yourself, Well, do I have enough instructions on the flip side of the coin in my power of attorney where my agent will understand what my wishes are on how I want them to carry out my financial affairs? Sometimes it's this like super blank check where people have all these powers given to a financial agent and no instructions at all. And it's great because it's great that you trust somebody, and a lot of times maybe that's enough for certain people. But some people are like, hey, these are my finances, and even though I trust this person, I want to provide some instructions or parameters on how they can exercise their power. Like, for example, when they can start acting on your behalf. So when we say planning a power of attorney would be, you want to make sure that you're giving your financial agent full authority with instructions. What that means is you're giving them full authority to act on your behalf with instructions on how you want their powers to be exercised so that they can really truly act in your best interest in a very informed way. All right, and then just moving on to the next type of document, when we distinguish documents and planning for a healthcare proxy, or like I said, a healthcare power of attorney, you want to ask yourself, hey, in this document, does my healthcare agent have that life or death power? So that power to be able to make end of life care decisions for me. And you want to ask yourself, okay, well, if my healthcare power of attorney kicks in after I'm incapacitated, are there any directions I placed in there for my healthcare agent to know what I want done once I lose that control over myself? So you definitely want to examine your documents because those powers are not always listed out in powers of attorney. And I think those are really important powers to be clear that your healthcare power of attorney has. So when we plan, instead of just creating a document, when we plan for a healthcare power of attorney, we ask our clients, hey, have you ever thought about organ donation? If you have, do you want to donate your organs? And hey, we also want you to consider your healthcare power of attorney to be HIPAA compliant so that your healthcare agents can actually access your medical records if they need to act on your behalf. We also like to include personal care plans. And what that means is, hey, if you lose your capacity and your agent has to step in to take care of you, you can outline exactly what your priorities are in terms of how you want to be taken care of if you lose incapacity. So for example, if you can, in your personal care plan, you can say, I want my agent to take me to church every Sunday because that's really important to me to remain in that community. Or I want my healthcare agent to make sure I get my hair groomed every month because beauty is really important to me. It's always been important to me and I don't want to lose that even if I'm incapacitated. So those are really personal details that are important when we actually plan in a healthcare power of attorney. All right, and like I said, with the last will and testament, normally I think of this as a document because it's just an instruction sheet to the probate judge. In it, you can add a few more wishes with adding some like specific planning priorities that you want to add into your last will and testament. But what I find normally is if people really want to plan and have their priorities integrated in their estate plan, I would say a trust normally is a better instrument to accomplish that. A will is just there to take care of any assets that have to go through probate. All right, so now we're moving into the risk area. We're slowly transitioning into understanding risks. So before I talk about what those risks are, I kind of want you to think about everything I've been talking about in this distinction between documents versus planning. When I say planning, essentially the big picture is I want you to have a complete plan, right? It's not just one or two documents coming together and working separately. So I want you to think about risks as this intruder coming into your house. And each document you have is a brick. So yes, you have, for example, if you have a living will, a healthcare direct, that's great. You're covered for end of life care. So you've got that blocking certain risks, but everything else is exposed. Or let's say you have a regular last will and testament and a living will and a healthcare power of attorney. So you have these three bricks that are covering this wall, but you're not avoiding probate. All the probate risks, all the government risks that come with probate are still coming through your wall. So I want you to think about planning really more as how can I really develop a complete estate plan. So this is just another iteration saying, okay, you have your trust, you have your last will and testament, you have your healthcare directive, but you still see some of those risks peeking through. So you really want to make sure all your documents are working together to provide that really secure coverage against those risks. All right, so this is the ideal. You see this beautiful completed wall. It's comprehensive. All the documents that are supposed to be there are there. Everything's working together. When you're alive, your powers of attorney are there, preventing risks from leaking in. After you pass away, you have a will and you have a trust, so you avoid probate. If anything has to go through probate, then you've got your will to back you up on there. Then you have asset protection instruments in there. So you're really covered when you have a comprehensive estate plan. All right, now we're moving into step 2 of our plan to bypass panic. Number 2 is know your risks. And I'm going to divide these risks into 4 different categories. Number 1 is government risks. We've already kind of talked about that with probate, but there's also other risks that I'll highlight. And also long-term care costs. I'm sure many of you have thought about this. Long-term care is really, really expensive, and that obviously poses a big risk on your estate. And other risks are your family or lawsuits. These are kind of, people don't really think of these issues as risks. They're unanticipated, but I'll kind of talk about why I still consider those as risks to your estate. All right, so with government risks, I've covered probate, but I want to talk about that guardianship and conservatorship. Like I said, without a power of attorney, the government, I consider a guardianship conservator a risk just because it's such an arduous process to have to set up in order just simply for somebody to be able to speak on your behalf. And with guardianships and conservatorships, once that person is appointed, they have an ongoing relationship with the court. In order to do anything with your assets, they also need to get court approval in order to act on your behalf. So it's not just, getting them appointed, that's the hassle, but also that ongoing relationship with the court that can be pretty burdensome as well. And then we also talk about taxes. A lot of people are concerned about estate taxes, but fortunately, most people don't have to worry about it. So in 2020, the estate tax exemption is $11.5 million per person. So if your entire estate is below 11.5 million, then you don't really have to worry about an estate tax being imposed. Missouri doesn't have a state estate tax. And if you're married, that threshold doubles. So if you're a married couple, then your estate tax exemption is $23 million. And then in 2020, that annual gift tax exemption is $15,000 a year. I will say, as you give those $15,000 a year, that amount that you gift away each year does count against that upper threshold. So it counts against that 11.5 million estate tax exemption in the end. But normally that's still not a concern for most of our clients. All right, so now I'm going to talk about long-term care costs. I'm sure many of you have dealt with this or at least have heard about them. This is a big part about what we do here at TuckerAllen. So here are just estimates about long-term care costs. So if you stay at home and you just use home health aid or something like that, the cost can run from $500 a month to $12,000 a month, which is insane. That's so much money. And a lot of times these people who need long-term care are retired and they've worked all their lives and saved up, built up their savings, and now they're just using it all towards paying for their health care instead of living a life that they want to live, or being able to pass on those assets to take care of their kids, their grandkids. In assisted living, it's $2,000 to $5,000 a month. It could be higher depending on which kind of facility you're using. And nursing home care can run from $5,000 a month to $12,000 a month. And same here, it can be higher if you want a nicer nursing home. So a lot of people are like, wow, yeah, I have savings, but I don't have savings to go through that every single month. So people ask, how am I going to pay for this? So a lot of people have, in asking themselves these questions, they find that Medicaid a lot of times is naturally brought up in this conversation. So you probably heard about Medicaid and how this is a program that can cover for your long-term care costs, but it comes with a lot of catches. So you probably heard, oh, Medicaid, they can take your home, right? Or that you have to spend down or give all of your assets away in order to protect your assets. Or you've heard that, okay, if I give my assets away, I actually have to wait 60 months or 5 years before I can even get Medicaid coverage. And so Medicaid really is a complex set of rules and exceptions, and I'm covering it very, very briefly today. If long-term care is a concern for you, I would highly encourage you to book an appointment with us so I can understand your situation better and that we can actually make a good plan about how to work with long-term care in your situation. But I just want to give that disclaimer. Everything I'm covering today with Medicaid, it's a very cursory explanation. It's really complex, and we can get a lot more into detail about it in a personal conversation. All right. So the 60-month or the 5-year rule is true. That's an accurate number. So how it works is when you apply for Medicaid, the day you submit the application, they're going to say, okay, starting today. So let's say November 24th is today. Starting from today, November 24th, and 5 years before today, in that 5-year period, have you made any transfers that are kind of illegal, like under Medicaid, not illegal by law, but illegal to Medicaid rules? And if you have, then you're going to incur a penalty period, depending on the amount that you transferred. And normally these transfers are if they're uncompensated. Of course, if you buy something, you give money away for something in equal value in exchange, that's a compensated transfer. Medicaid's not going to fault you for that. And there's certain exempt types of transfers, certain things that are okay to transfer without incurring a penalty. But most transfers, especially if you're thinking about gifting to your kids or to other entities, those are going to count against you. And for example, if you transferred $20,000 in the last 5 years, they would take that $20,000, no matter if it was 5 years ago or 2 years ago, just in aggregate, how much have you transferred in the last 5-year period? And they're going to divide it by a penalty divisor. And this changes every year. In Missouri right now, it's roughly 6,000. So you take out 20,000 divided by 6,000, and that equals the number of months that you have to wait before Medicaid can kick in to cover for your long-term care. So here we have a list of common violations when people apply for Medicaid. I've already covered gifts, so be really careful about gifting assets away, especially if you think long-term care is in the horizon for you or for your spouse. Another thing is lack of documentation for those transactions. Medicaid is very detailed. When you submit a Medicaid application, they want to see exactly where the money went and what you got for it. So make sure you keep all your receipts and that you have in your bank statements, you have a very clear kind of document trail for what this transaction was, because you need to be able to explain it to Medicaid. And then another common violation is creating irrevocable trust during this 5-year period. It's not the end of the world. Irrevocable trust can still be useful even if created in a look-back period, but definitely not as useful, because essentially a transfer into the irrevocable trust is treated as a gift. And irrevocable trusts are used because I like to think of irrevocable trust almost as this lockbox. So when you have this lockbox, you're giving up control and management of these assets that you put inside this lockbox, but you're appointing somebody you trust as trustee of this lockbox to be maintained for your loved ones. So a lot of people see that, and it is the more ideal instrument for asset protection. And so when you make transfers into an irrevocable trust to protect and preserve those assets for your kids, that will incur a penalty period. So you normally have to wait for the whole look back period, the whole 5-year period, before those transfers into the irrevocable trust are kind of blinded from Medicaid's eyes. So if you're thinking about asset protection, even if long-term care is not on the horizon for you, I would highly encourage you to consider irrevocable trust as part of your estate plan Normally when we create irrevocable trusts, we create it with a revocable. So you're not putting everything in the lockbox all at once. You're still managing a lot and maintaining control over a lot of your assets. It's just that you can start making these transfers into the lockbox and that you give yourself that enough of a buffer time for that 5-year period. All right, so those are kind of more of the anticipated risks, the government risks and the long-term care costs that we've all heard about and that we think about. But now I'm talking about kind of unintentional risks. So when I talk about how your family is a risk to your estate, this means, like, for example, if you have a blended family, sometimes you have to build in more provisions to make sure that everything is equitable amongst the kids and the stepkids. Or if you want to make sure that if you and your spouse are creating a joint trust, you build in a remarriage provision saying, hey, if one of us passes away, the surviving spouse, if he or she remarries, then I want to make sure that she can't change the terms of this trust and that the terms of the trust are still pertaining to my kids, and that what we set out, they're still going to get those assets that we plan for. Another avenue for which your spouse can be an intentional risk is if something were to happen to your wife or your husband and they were to need long-term care themselves. How do you make sure that you can take care of your spouse without making them ineligible for those benefits programs? And with respect to kids or other beneficiaries, you also want to consider who the kids are. Sometimes we don't like to think about, our kids being a potential danger to us preserving our assets, but depending, your kids best, depending on the type of child, some kids are more spendthrifty than others. So you want to make sure that, hey, if I have 3 kids and 2 of the kids are really responsible, one of them just like spends their money like sand through your fingers, then you want to make sure that you distribute their share to them in a way that monitors how they can use those assets that you provide to them. And for that, we would definitely encourage you to create a trust to build in that control. And there's also a whole list of other things that can happen in your children's lives that would kind of pose as risks to your estate. Like if they're married right now and they get divorced, how do you make sure that what you leave to your kids is not just going to end up in your in-laws' hands? Or if you're okay with that, that's fine. A lot of people, they want to make sure, hey, if they get divorced, I want to give it to my grandkids instead of my daughter-in-law or son-in-law. And other really generous grandparents, I've been asked about, well, how do I provide financial aid for my grandkids' college? I want to make sure that, college tuition isn't a barrier to their education. And how can I incorporate that into my trust so that the college tuition isn't just draining everything that they have? All right, and then another category of unanticipated risks are lawsuits. So this can include both yours and your beneficiaries. So when you have, say you just get into a car accident or something and somebody instigates a lawsuit against you, your assets, whatever is in your control, is open for their claims as well, open for the settlement in the lawsuit. So you just have to be careful. In this situation, I would say an irrevocable trust is quite important because anything that you put inside an irrevocable trust that can be protected from future creditors. Of course, if you have an ongoing lawsuit right now, just transferring it into the irrevocable trust is not a wise idea because that doesn't protect anything, and it might even be construed as trying to hide something. But if it's something that you're concerned about and concerned about future creditors, I would highly encourage you to consider that irrevocable trust. And even for your beneficiaries, in terms of passing it down to them, if you know that your kids are going into a field of a profession that can be ripe with lawsuits, then maybe you want to make sure that your assets that you distribute them to them don't just go directly into their hands, but maybe into a subtrust so that the assets you provide for that child is not going to be open to that child's lawsuits or other creditors. All right, now we get to step 3 of how to bypass panic in your estate plan. So it's about knowing your options. So now that we know our rules and what risks we want to avoid, what exactly are the options for an estate plan? So in the world that we're talking in, we talk about elder-based estate planning. So what does that mean? I like to think about elder-based estate planning as being person-centered. So this is you, you're creating an estate plan. So we ask, who is in control here? Who is the person whose assets are in play and whose assets are being put into a trust? And then you also ask, well, who is to benefit? Yes, so like the grantor, you, like mom and dad, are the ones in control, but the kids are benefiting, or are you wanting each other to benefit first and then the kids? So we really want to make sure it's based on you and your life, and also who you want to maintain control. Do you want to control a trust together, or do you want to each control your individual trusts, stuff like that? And another important consideration in estate planning is the different time points at which that you want to plan for. So number one is when you are alive and well, or when you and your spouse are both alive and well. So when you guys are alive and well, essentially you kind of want to just keep living as you are and have powers of attorney in place. But in terms of assets, being able to use those assets and live a full life to your priorities. But then the second age point is, okay, but what if one of you becomes incapacitated? How do you want the spouse to be able to manage your assets for you? Or how do you want these assets to be managed? Do you want the spouse to be the one to be in control? So kind of planning ahead at these various checkpoints in your life. When you're alive and well, when you're incapacitated, and then also after you pass away, what do you want done when one of you passes away? And the other question is, if one of you passes away, but then the other spouse becomes incapacitated, or if the other spouse remarries, or if the other spouse passes away. So you really want to make sure each of these conditions, you've got a strategy in place. And then so after both you and your spouse have passed away, how do you want to make sure the kids are taken care of? Whether they're divorced, or if they're disabled, or if they're just alive and well, they're responsible people. It really depends on your circumstances. But that's why you, I would say you definitely want to talk to an attorney so that you can talk about these potential circumstances and how you want to plan ahead for them. When we talk to clients, when we ask, what are your goals? What are your priorities in an elder care plan? These are the most common answers we get. So a lot of times people are saying, I want to stay in control. These are my assets. I just want to make sure I have a plan for them, but I don't want to give up control. And I also want to make it as easy as possible for my family. The whole reason I'm doing this is so that nothing has to go through probate, so that my kids will be able to get their shares, or my wife and my husband will be able to get their shares as easily, as smoothly as possible. And in the same vein, that just means keep it simple. And I want to take those goals that I hear from you guys and kind of translate it to what our goals for you are. So this is just to loop back to what we discussed at the very beginning of the seminar, and it's to know the difference between documents and planning, right? So when we create an estate plan, I don't want you to think about each of your documents as separate players. I want you to think about them as a whole team. And I think about them as an estate plan, emphasis on the plan. You want your documents to work as a team together so that they fill in that wall for you. Okay, and our goals are also, we want you to understand all the costs that come with planning or not planning. Like for example, if you only choose to do a will and you don't want to do a trust, I always alert my clients, if you're just doing a will, I can do that for you, but I want you to understand that you're not avoiding those probate costs, that probate administration process. So know what costs are in the line for like what you're planning right now and what's coming down later in the road. At TuckerAllen, for our services, everything is on our website at TuckerAllen.com. So you can see all our services that we provide and also the costs that come with providing those services. So we try to really be as transparent as possible and really keep it with no surprises for you. And then the last goal that we have for your plan is I want you to know all of your options. So I give you, here's option A, B, and C. I'll talk about the pros and cons of each one, but in the end, you are the one to pick the right plan for you. I'm here to give you that information, but you're the one to let me know what your priorities are and what is the appropriate plan for you. Okay, so number one, if you don't do anything, you can just use the government's process in terms of your options for creating an estate plan. I say estate plan in quotes right now because this isn't really a plan. This is saying, okay, if I don't do anything, what happens? If you don't have a power of attorney, we talked about somebody has to be appointed as a guardian or conservator just to speak and decide on your behalf. If you don't do adequate planning, assets, if you don't have a will or a trust, then you're leaving it up to the states to decide what to do with your assets and who to appoint as your executor. So option one, I would say, is not a good option, but it's there to let you know that the law builds in this safety net for you, but really the safety net is often not adequate for most people. And then option two is planning for long-term care costs. And planning for long-term care costs, we kind of talked about this already in terms of coming in, talking to us about working with asset protection, potentially talking about applying for Medicaid, whether that's an appropriate option for you and what the costs are. And so with long-term care, you have multiple options. Of course, if you have enough money, you can just privately pay. Unfortunately, for most of us, that's not really an option. Or if you plan out ahead enough of time, you have long-term care insurance that can kick in, but often long-term care insurance that can be quite costly just to maintain in the meantime. So that's why we talk about Medicaid. And I already had discussed how Medicaid evaluates Medicaid eligibility with that look back 16-month period. But I like to think of long-term care planning with Medicaid into two categories. So number one is a crisis situation, and number two is a pre-planning situation. So when I say crisis, I mean, this is the client that comes in and says, I need to get into Medicaid like tomorrow. I need the coverage for long-term care tomorrow because my health condition is already not in a good state and I need assisted living, I need nursing home care. So in this situation, we have certain strategies. So unfortunately, normally with the irrevocable trust, that whole 60-month period, this is not as an ideal situation to use that in, but we have other strategies that we use, such as caregiver agreements, using spend down. Spend down is actually, it gets a bad rep, but a lot of times if you talk to an attorney that works with long-term care, we know what assets are exempt and what assets can you put towards spending down on so that it's smart spending down, so that you're actually spending it towards something that you would have spent anyways, but that you're actually just helping you qualify for Medicaid in a smarter way. So there's just different strategies for crisis planning, and the strategies really depends on each family's situation. So definitely come in and talk to us about that. And the ideal situation with planning for long-term care is pre-planning. So what if you plan now when you're healthy? This is when we really love to use those irrevocable trusts, creating this lockbox, safe lockbox for you. When you have more than 5 years down the road, you can start transferring assets in there to protect those assets, and you don't have to worry about Medicaid being able to lay claim against those assets in that lockbox. So if you're in that situation right now, please come in. We can help you create an irrevocable trust. And you can just have that as part of your tools, as part of your estate planning team, so that asset protection is also another goal that's accomplished in your estate plan. All right, so in terms of protecting assets, I already talked about this in terms of you want to make sure you have the right trust to protect your assets. So when we talk about trusts, there's a few of them. And normally, a lot of times we create revocable trusts. Revocable trusts, they don't go so far as to asset protection, but they do avoid probate. So this is where a lot of times people, when they come in, they say, hey, I want a will, and they find out, hey, a will doesn't actually avoid probate, then they want a revocable trust to couple with their wills. I like to think of a revocable trust instead of a lockbox. I like to think of it as a basket. You are the trustee of this trust. You hold this basket while you're alive. Anything that you title inside this basket is you're still in control of, and anything inside of this basket is avoiding probate. So that's why a lot of people like revocable trusts, because they maintain that control and they're avoiding probate. However, if you want to protect your assets, this is where we say, hey, the basket is great, but why don't you add a lockbox with it? so that you can put some things in that lockbox, keep some things in the basket, keep whatever you want to keep in the basket to sustain your quality of life. And I would say these trusts working together provide the fullest coverage in your estate. All right, so how do you create a rule book that works for you? So number one, when you come in, we create the rules. You tell me what your priorities are, and I create those rules in your will or trust, depending on which document you want to create. And then after creating those rules, on the day of signing, when you come in, then I say, hey, we want to make sure you integrate your rules. You've got this beautiful basket, trust basket, with all of your rules set in. Anything in those assets have to be distributed according to the rules that you set. However, the basket is operative on the fact that there's something in the basket. So you have to integrate those rules. That's your homework. We can do your homework for you. That's a service that we provide. But a lot of times people want to do their own homework. And so what I mean by that is making sure that your bank accounts have the trust set up as a beneficiary, or your investment accounts have the trust set up as a beneficiary. And with a house, we actually set up the beneficiary on your house for you. We'll help you record the deed and everything. So that one, most of the time, we can take care of for our clients. But of course, in the future, if you buy another property, make sure every time after you create an estate plan, every time you acquire a new asset, ask yourself, is this tied up with my estate plan? Is it titled with my trust? So that's what I mean by integrating your rules. All right, number 3. This is an often ignored step, but a very, very important step. So this is maintaining your estate plan. So essentially at signing, when I have clients come in, I'm like, yeah, you're done. You have peace of mind here. Enjoy the holidays. But please check your estate plan every so often. Life changes, families change, the law changes, your health changes. With changes comes changes in your estate plan. If your family member moves away and it might not make sense for them to be your first choice financial agent anymore, then maybe appoint somebody else, come in and change that, update it. So we definitely encourage you, even after you have a good estate plan in place, keep an eye on it. Visit it every year or so that you can make sure that your estate plan is still working with your new life or with the new circumstances of your beneficiaries. So please do not ignore this step number 3. It's very important. All right, so that we're nearing the end of the presentation, and I hope that I accomplished the goals that I had set out. So number 1, I hope I helped you identify if you have a current plan, whether it meets your goals or not, and to also help you understand what exactly are the strategies in place that can help you protect you and your assets. And lastly, show you what's missing, if there's anything missing in your estate plan. For example, you only have a will, maybe this is a time for you to consider adding a trust to it. Or if you have a trust or a revocable trust, maybe this is a time for you to consider adding that asset protection aspect of it and add on an irrevocable trust. All right, so this is just a review of all the questions that we get from our clients to be the most common questions. So I hope that you're able to understand most of them now. If not, obviously, you can still contact us, book an appointment with us, and we're happy to answer these questions and walk you through your estate plan. So can you protect your assets from the government, long-term care, or family? The answer is yes. And what is a trust? So I talked about the revocable and the irrevocable. Remember, revocable is a basket, irrevocable is a lockbox. And then how can I avoid probate? So when we talk about avoiding probate, we're talking about trusts, because wills do not avoid probate. Do I need to avoid probate? Most often, yes, because it's not a good thing to go through. It costs quite a bit, it can take quite a while, and it's just, you don't want to deal with the courts if you can help it. And then should I give stuff to my kids or other people? And remember what I said about gifting? Whenever we think about gifts, we have to be really careful, especially if we're thinking about long-term care, because you don't want to accidentally jeopardize yourself to a penalty period. And then if I give my stuff away, do I need to wait for 60 months in order for it to be safe? And the answer to that is, I mean, it's safe in the lockbox if you put it in an irrevocable trust, but you have to wait out that penalty period if you apply, depending on however much you transferred before you can actually receive that long-term care coverage. All right, and hopefully you can answer these questions now on your own. What is a power of attorney? Power of attorney for finances, this is somebody that you are sharing your financial decision-making powers with so that they can act on your behalf. A healthcare proxy is the same idea, except they're able to make medical decisions for you. And a living will is that direct testament as it pertains to end-of-life care. And what is the difference between them? I'll just cover that. Which do I need? I would say all of them, especially all of them, especially right now. How can I plan for my disabled beneficiaries? I talked about how you can build in potential sub-trusts in your trust so that your beneficiaries would not be ineligible for certain benefits programs, and that you can kind of maintain more of that control about how those beneficiaries can get their share. Are your IRAs safe? So normally with the IRAs, we think about this as integrating your rules. So after you create a trust, after you create an estate plan, we give you directions about how to set up beneficiaries on your IRAs so that it can be optimally passed to your loved ones. And then how can I avoid estate taxes? So we covered taxes and covered that estate tax exemption, about 11.5 million per individual, and married couples 23 million in 2020. So for most of you, it won't be that big of a concern. All right. And if you take nothing else away from today's session, I think this is the biggest takeaway. Remember that distinction between documents and planning, right? You don't want separate players working on their own. You want your estate plan to be a lot of teammates coming together, making sure that you have this whole complete wall set up to prevent the risks from leaking in so that you can mitigate against all possible risks and that things can be protected and administered exactly according to your wishes. All right. So the next steps, I would say, are to set up a one-on-one discussion with one of our attorneys here to discuss your future plans. And even if you have a current estate plan, come in, we can review that for you, let you know if that is something that you want to update or answer questions about. And I think in that one-on-one discussion, we can really dive deep, and it's your opportunity to get some personalized answers rather than me just talking to you here in a very broad scope about questions that are most important to your family and your situation, as well as coming up with a customized estate plan for you to help you potentially, if you want to add that asset protection aspect to your estate plan, we can definitely do that. Like I said earlier, we do fixed pricing here at TuckerAllen, and all the prices are available on our website. So really transparent, just go on TuckerAllen.com and you can see all the services we offer and the prices that we offer them at. And I do want to make a mention for all the attendees that joined us today, you are eligible for a $50 discount on an initial consultation. So normally when people come in for initial consultation, there is an initial consultation fee. Normally it's $150, but if you come in, we're offering that $50 discount for that initial consultation. And here you can book online at tuckerallen.com/get-started. And if you just go on tuckerallen.com and make a booking, you can insert that coupon code TA seminar so that we know that you heard about us through the seminar and you can receive that $50 discount on the initial consult fee. So this is just a quick process flow chart about how we normally do things at TuckerAllen and how kind of quickly we can get these documents done to you. So today, number one is the presentation. Number two, if you go on tuckerallen.com, and right now, holiday season, I think is a prime time to get this done. Make it a year-end gift to yourself. And then at that initial consultation, I'll get your information, answer questions for you, and we can talk about which plan makes the most sense for you. And then we can engage on a client engagement agreement so that you are officially our clients. And it takes us about a couple of weeks to finish drafting those documents for you. And after we finish drafting it, we upload it to a secure client portal. You'll get a username, a password. You review your drafts. After you get that, you let me know any questions you have, any changes that you want to make. And after we get your seal of approval and that green light, we'll go ahead and have our signing meeting where we will witness, notarize, and just execute that document. And then you can finally be at peace, enjoy the holidays, have that peace of mind that you have an estate plan set up for you. And I know right now, some people are pretty antsy about coming into our offices, and that's totally understandable. So I do want to let you know that we are offering virtual consultations. All you have to do is when you're making that appointment from our website, just say, I want to book a virtual consultation. That way we'll know to send you a link so that we can meet virtually and get that. We can have the exact same conversation just from the comfort of your own home. All right, well, thank you for joining us. I'm really glad that you were able to take time out of your days to join us today. Thank you.